Welcome, ladies and gentlemen. My name is Margot Burke, and I am an elder law attorney, and my office is located in Newburyport, Massachusetts. I am, however, a resident of Byfield. I've been asked to kind of go over what the basic components of an estate plan and certain particular documents that you might find important and may not know what they are or how they work. I'm an estate planner, which means that I use the same toolbox that all other estate planners use, which is wills, powers of attorney, healthcare proxies, trusts. But like anybody's toolbox, like a carpenter's toolbox, the tools are just there to perform a particular service or a particular deed, like putting a nail in the wall and hanging a picture. These documents are similar. They're just forms that are sitting there in the estate planner's toolbox, waiting to be customized for each particular client and what their needs and desires might be. Now, this is a totally new way of doing things. I'm obviously working from my home computer, and I'm hoping very sincerely that it's going to work. So what I'm going to do now is I'm going to share my screen. Yeah, I actually learned how to do this. You know, it means you can teach an old dog new tricks. I'm going to share my screen and go through the particular issues that I want to talk about today. I will let you know that I will make this information available to the Council on Aging in Newbury, so that if you want to have a copy of what we've spoken about today, you can pick one up at the Council of Aging, and you can also leave with them any particular questions that you might have. Now, I can't answer specific questions as to your individual situation, but I can certainly clarify any misunderstanding or confusion about what these documents are and how they work. So let me get technical here, and I am going to share my screen. Where is it? There we go. All right. So we're going to start. I'm just going to start, if I can, with just a little bit about elder law. As I said, I'm an elder law attorney, so I take this toolbox and I use the tools in the toolbox to work with people who are either older. Now, the older I get, the farther old gets for me. So older, maybe have a chronic illness, maybe are just concerned and are risk averse, to prepare their estates for the different question that elder law answers. Most estate planners work to answer the question, what happens when I die? Elder law attorneys are more interested in and concentrate on what happens if I don't die. But enough about elder law. Let's go on to the next slide. So what are the goals of estate planning? One would be to pass assets on to your family. Two would be to save on taxes. Now, we're not talking about income taxes here. We're talking about estate taxes. And if you die with $1,001 in your name alone when you die, then you could be subject to an estate tax in Massachusetts. And the third goal for estate planning is to plan for long-term care, if that is a concern. So, general categories of estate planning. Basic estate planning is for everybody. And this includes kids who go off to college, they turn 18, you lose all legal authority to get information about them, to be able to make decisions for them, even when it's to help them. So my recommendation has always been anybody over the age of 18 should at least have a durable power of attorney and a healthcare proxy that contains an advance directive. Now we'll get into what an advance directive is shortly. Then, as I said, when you've accumulated a healthy nest egg and could have estate tax issues, then we might get into trusts and gifting. And if you are older or ill, maybe you'd like to look into long-term care planning and look at what Medicare and Medicaid might cover and other things like home care, nursing home care, long-term care insurance, and assisted living. But that's for another day. That's just a tease. Okay, durable power of attorney. Now, first of all, a power of attorney. The person that you give this authority to does not have to be an attorney. This is a term of art that has lasted, I don't know when it started to be called that, but you certainly don't need an attorney to be your agent under a power of attorney. Now, why do we say durable? Well, first, let's not get ahead of myself. A power of attorney is a document by which you, and you're called the principal, authorize another party, that's called the agent, to manage and administer your property during your lifetime. And this document is only supposed to be used if you are either temporarily or permanently unable to manage your own financial and business affairs. Why do we call it durable? We call it durable so that it will endure. It will endure past the point of your disability, whether it's cognitive, physical, whatever it might be. You really should have a durable power of attorney, because a general power of attorney ceases to have authority once you become disabled and can't manage your affairs. So remember that, durable. So generally speaking, a power of attorney is effective when you sign it, and but it's only supposed to be used when it's needed. So there are other ways of signing powers of attorney. Some people are a little bit reticent to give that authority immediately to the person that they name or persons that they name. So you can have something called a springing durable power of attorney. This is a document where it says that it will not become effective unless the agent brings from your doctor, authorization or attestation rather, that you are not able to manage your affairs. This is what's wrong with you. And then the power of attorney springs into effect. I don't particularly like those. First of all, it makes a lot of banks and investment firms very hesitant to recognize, because they're not really sure exactly what this is all about. And then you really have to share personal health information with those entities in order for them to accept the power of attorney. I prefer, and it's not written here, but I prefer, if this is a concern, you can escrow your power of attorney with your attorney, and your agent needs to make those that situation proven to your attorney that you're not able to manage your own affairs and the reason why. And that's signed by one or two attending physicians. So I think that's much better, because it still keeps your personal medical information private. And then there's the limited power of attorney. That's used sometimes, like if you're selling a house and you can't make it to the closing, you can give someone a limited power of attorney to sign the closing documents for you. So that's basically, it's for a specific purpose, and that's it. That's all it's good for. So hopefully that's pretty clear. Now, a healthcare proxy. A healthcare proxy is very similar to a durable power of attorney in that it's a document that while the, whoops, uh-oh, you're going to really laugh with this. Hold on just a moment, please. I have to fix my equipment. Okay, hopefully we're back in business and you can see me. So I was talking about healthcare proxies. Healthcare proxy is a document wherein you appoint someone that you trust to make healthcare decisions for you if you're unable to express those decisions and those wishes to a healthcare provider. This person has to be able to express your wishes. So what I tell people in these cases is you really need to have a conversation about exactly what you would like to have done under certain circumstances when you're not able to express those wishes yourself. So as I said, this is a conversation with both your agent and your backup agent so that they are not confused or unaware should their services need to be accessed. I've had a number of people who have been named as healthcare agents who didn't know it. Their parent was in the hospital. The doctor says, we want to do X, Y, and Z. Do you think your mother would want that? And the agent goes, oh, I don't know. Nobody ever talked to me about it. This is not an easy conversation to have. It's not easy necessarily for you, but it's really sometimes more difficult for your agent if your agent is a child. Sometimes it's easier with a friend because they don't have that same relationship with you. But it's very important. There is a website called The Conversation that gives you some hints as to how to start this conversation, how to conduct it, and I will have that information attached to the handouts that I give to the Council on Aging. So very important, in a healthcare proxy can be used in case of accidents, illness, lack of capacity. If you have done a healthcare proxy before you go into the hospital or to the doctor and they put another one in front of you, don't sign it. Tell them you have a healthcare proxy or have your healthcare agent there saying, no, he or she has a healthcare proxy. Because if you sign another one, then it negates the one you signed before. But people now are very prone to sticking a healthcare proxy in front of your face, which is something they never used to do before. So you have to be aware of that. Also, as long as you can communicate in any way by squeezing someone's hand for yes and no answers, by batting your eyelashes, by wiggling your ears. You remain in control of your health care. It's only if you are totally unable to express how you feel, or maybe you're under the influence of medication, then your healthcare agent will be there to speak for you. Also, the healthcare proxy needs to have what's called an advance directive or living will that addresses extraordinary measures that may or may not be taken. Now, in Massachusetts, we don't really have a statute or a law that backs up a living will, but instead we have something called, whoops, we have something called an advance directive. And this advance directive has even more substance sometimes than a living will. That's where you get to write out exactly how you want to be treated in probably a very severe or life and death situation. So that's contained in the healthcare proxy. And you can only have one agent at a time. This is by law in Massachusetts because the whole point of a healthcare proxy is to have somebody who is the point person for the healthcare provider so that they don't end up having to make a decision based on people having an argument in front of them. Oh dear. I'm having all these, I apologize, ladies and gentlemen, but I've never done this before. So, okay. Now, living will medical directive. Again, a living will expresses what medical actions should or should not be taken in the event you become incapacitated and are unable to make decisions for yourself. These decisions can be minor, or they can be concerning terminal illness or life-sustaining procedures. And there are other forms too. There's do not resuscitate. Do not resuscitate means that if you should code or essentially die, you don't want to be, you don't want any care given. You don't want somebody to try and resuscitate you. Now, this form is only good in the hospital. Do not resuscitate does not work at home. There's also, it used to be called comfort and care. And you can also have a do not hospitalized form that you can put on your, usually people tend to use refrigerators where they put in, instructions should they not be able to communicate and no one else would be there. You can, in your healthcare proxy, you can give instructions as to whether or not you want to be an organ donor or you don't want to be an organ donor. There's also palliative care forms. They're called MOLST, Medical Orders of Life-Sustaining Treatment. This is a new form that's generally a step-down form for people who are very ill, very old, or just don't want, I'm fine right now, but if this happens, then I don't want this done. It's an opportunity to really be more expressive about your needs. This works at home. So if the EMTs are called and they see this, it's pink on your refrigerator, then they will read it and that absolves them of the legal obligation of resuscitating you. Because that's basically what they're called to do, unless they get, legal, instructions otherwise. Okay, so what do we have? Oh, and we believe that documents should be updated periodically. And when I say we, that's the royal we, estate planning attorneys, elder law attorneys. You should follow the 5 Ds and update your documents. If it's been 10 years, I actually recommend 5 years, but this worked better. The F didn't fit in here. If there's been a death, a divorce, if you've declined in health, or you've received a diagnosis, that's when you should take your estate planning documents out and review them and probably update some of them. So it's not here in the handout, but we also do something called a HIPAA authorization. A HIPAA authorization is part of the Health Insurance Portability and Accountability Act that is a wide-ranging law, but there is a part of it that is in regard to the privacy of personal health information. So first of all, when you go to the doctor, they generally make you sign something. What you're signing is you are giving them permission to share your personal health information with the insurance company. Otherwise, they can't bill the insurance company. So that's a very easy to understand part of this law. But if you want certain people to be able to have access to your medical information, but not necessarily have any decision-making ability, then you would fill out something called a HIPAA authorization. And the people named on that document will have authority to go to the doctor with you, to have the healthcare agent share information with you. Maybe you can, that person can go down to the medical records office and get more information, or ask for records to be sent for a second opinion. It kind of spreads the activities, if you will, when someone is ill and in the hospital. I don't know how to stop these. Anyway. Okay, so one of the other things that people are confused about, if you will, are trusts. When I was growing up, the only people who really had trusts were the Astors and the Rockefellers. Now, trusts are pretty ubiquitous, and they can be used for, again, totally different purposes. You may have heard the term living trust. So it's very simple. A living trust is just a trust that you created and signed while you were alive. It can be revocable, which means that you can change anything at any time. You can terminate it. You have access to everything that you might put into this trust. And it can be irrevocable, which puts limits on your ability to access and affect property that's held in the trust. The opposite to a living trust is something called a testamentary trust that is part of your last will and testament. And most often now, these trusts are used in the context of long-term care planning, which I won't go into for this presentation, but maybe they'll call me back for another one. So as I said, a living trust can be revocable or irrevocable. A testamentary trust only comes into being when it is funded or filled through your will with the assets that you owned when you died. Irrevocable trusts are used for tax planning, for long-term care planning, for various reasons. So again, it all depends on what your goal is, what tools will be used, and how they will be used. What's next? Okay. The kind of trust used is governed by individual circumstances. Sometimes it can be used just to simply manage your assets, to put everything under one roof, not to hold anything in your name alone. And when you die, you can be the trustee of this trust. You have total control while you're alive. And then when you die, you've named a successor trustee who has almost immediate access to the assets in the trust. When I say almost immediate, there's always paperwork, right? Can't get away with not having paperwork. But it certainly streamlines the process. Probate isn't a 4-letter word, but it can take up to a year to finalize a probate, which is when you take your will and file it with the probate court. I don't know if we'll get into that here, but that's what probate is. So there's also, you can use a trust if you have a special needs child that you want to leave assets for, but not directly, because if you leave them directly to the child, they could be knocked off of whatever public benefit program they're benefiting from. One thing I'd like to make very clear is you do not have to disinherit a special needs child. You don't have to say, oh, I'm going to give everything to Jimmy and Jimmy will take care of his sister. First of all, that's a terrible onus to put on Jimmy. And secondly, it's not necessary. You can easily have part of your will, if you want to go with a will, or a clause in your trust that says X percentage to be used to fund the Johnny Smith Special Needs Trust. So just bear that in mind, that you don't have to disinherit, and you shouldn't disinherit a special needs child. Trust can be used to hold life insurance policies. There's a kind of trust called an irrevocable life insurance trust, which essentially, if you have a very high estate tax exposure, you can purchase a life insurance policy. Well, actually, you don't purchase it. You create this trust, and the trustee of the trust purchases it. And it's meant to make up for the amount of estate taxes that your estate would have to pay when you die. Again, it can be used to remove assets from a taxable estate. So if you transfer assets into a trust, after 3 years, they're not considered part of your taxable estate. And each of these has some benefits, some liabilities. So that very much depends on, again, what your goals are, what your needs are, and what you decide you really want to do once you look at everything from both sides. And trusts are also used in the planning for long-term care needs. What is a trust? A trust is really a rule book, okay? It's a bunch of papers that express, there's legalese, there's always legalese, other people call it boilerplate, but lawyers' jobs are to think of any possible thing that could happen. The chances of something happening, like, some of these clauses, is so remote, it doesn't even appear on a calculation. But on the off chance that you inherit oil futures or some other, out of the way asset, the trust has language to provide for that. But it's basically a rule book. This is who I am. You will see what property is, held in the name of the trust. this is how I want that property used after I pass away, because I get to have it all the time that I'm alive, unless it's an irrevocable trust. And that's a whole different story. So a trust can protect your property by preventing distributions of money or property until your child matures. So maybe you don't want an 18-year-old getting a huge chunk of change. You can say, I don't want my child or my grandchildren to receive anything until they've reached at least the age of 20. Some people say 21, some people say 25. I had a client in my office one time who said, I don't want them to be able to get, I don't want my children to be able to get my money until they're 60. And I looked at him, I said, well, that's a little extreme, isn't it? And he said, no, they can't save a dime. I'm their retirement account. So you see, it all depends on your individual circumstances and situation. It's a professional administration, management of your assets. If you have a professional trustee, it provides something called a spendthrift protection, which generally, while the asset is held in the trust and not in your child's name, then your child's creditor cannot gain access to it. Once it goes into their name, that's a whole different story. You can have assets distributed to your children in a staggered way, maybe, and you can also say if they need it for medical care or for education, the trustee can have the discretion to spend some of their trust money on those things. You have to, again, conversation. Talk to whoever the successor trustee is going to be so that they know exactly what your intentions were when you set up this document. Could lower income and transfer of taxes? I'm not a CPA, so I generally work with CPAs when that's a goal. And definitely can protect against the cost of long-term care depending on when and how it's done. So what's next? Oh, I think this is interesting. And I don't know if this is part of what I've been asked to do. And frankly, I don't even know how long I've been speaking. But ownership of property. In order to distribute assets through a trust, the trust must own the property or be named as the beneficiary of the property, like your house. You can put your house in the trust, you own the house as trustee, and then when you die, the house or its value is distributed according to the terms of the trust. If you want to distribute assets through your will, you have to own the property outright. Jointly owned property with rights of survivorship, generally that's spouses, or if you are owning a house with a sister or with a good friend, you can say either we own it jointly with rights of survivorship, which means that when one person dies, the ownership passes to the surviving owner, not by the terms of your will or your trust. Joint ownership. Joint ownership can be in bank accounts, investment accounts, real estate as joint tenants. Tenants by the entirety is a particular ownership interest for married couples. I'm not really sure what the origin of that is either, but it's the case. They are automatically joint tenants with rights of survivorship. And you can also retain something called a life estate. And if we have time, we'll get into that. But it's important to understand that if Your bank accounts, investment accounts have beneficiary designations. It's going to go to the beneficiary named on the account or the policy. Same thing with life insurance. If the estate is named, then it will go through your will. So what are the beneficiary designations? You can have life insurance that names a specific person. Bank accounts can say in trust for or payable on death, just like an investment account, or TOD, transfer on death, depends on the institution. And then retirement accounts, IRAs, 401ks, those kinds of things, you put a beneficiary generally on those. And those have tax consequences, which are definitely too much to go through at this point in time. So now we get to your will. What does your will do? Your will manages the distribution of all assets that are not controlled by survivorship provisions, beneficiary designations, or held in trust. If you have no will or other plan in place, then your assets will pass by what they call intestacy. That just means you don't have a will, you're not testate. So the Commonwealth of Massachusetts has a chart that says, okay, this person died without a will. Which survivor is the closest in blood relation? And they go from there. And there's a whole chart. It goes up, it goes sideways, it goes down. You want to avoid that if you possibly can, because doing a will is not complicated, and at least you know that what you have is going to go to the person or persons that you want it to go to. It can distribute your tangible personal property. So what's tangible personal property? Tangible personal property is your stuff, your couch, your dog, your car, your record collection. That's tangible. In other words, you can touch it. Yeah, your dog is personal property. So as an aside, you really should make provisions if you have a pet as to what's going to happen to that pet if you die and they're still alive. And then you can name personal representatives. People, they used to be called executors, executrix. You can name people that you trust to shepherd your will through the probate process and make sure that everything gets distributed to the people that you want it to get distributed to. And then there's something called a pour over will. That's when you have a trust and you've delineated in the trust exactly how you want things to go. You still need a will, because a will goes around in your estate and sort of acts like a dustbuster and says, oh, is there anything left that we didn't think about? And if there is, then I want it distributed according to the terms of my trust. So that's your will. Okay, let's hold on a minute. Okay, I'm sorry, ladies and gentlemen. I'm trying to figure this out. No. Okay. Well, I should have figured out how much time this had taken up. And I don't know how to pause it. So I think we will just stop sharing my screen. We'll see if I can figure out how long this has been going on. Well, ladies and gentlemen, I apologize for the stops and starts and the perhaps not total professional level of this presentation in terms of the technology, but I hope that you got the information that could be useful to you through the subject matter that we covered today. And as I said, I will be leaving handouts with some additional information with the Council on Aging. Let me just add, your healthcare proxy, there is a Massachusetts, what they call statutory healthcare proxy. This means you don't have to go to a lawyer, you don't have to go to a doctor. You can Google it, go to the Google, or have somebody do that for you. Massachusetts Healthcare Proxy. You can print it out, follow the directions, and that is perfectly acceptable and functional. So unfortunately, we don't have that in Massachusetts for powers of attorney. They do in New York, and they might have that in New Hampshire, but not in Massachusetts. So that's all of the different things that I can think of for now. As I said, I hope this has been helpful. And if you have any questions, leave them with the Council on Aging, and I'll be happy to answer them. Thank you, and stay safe and stay warm.